Okay, welcome to class. Thank you for joining. Quite a small number of people. There should be more. Just give me a second, please. Okay, there've been some um, inquiries on the group about the YouTube videos. Yes, I will be uploading the videos on YouTube like previously. Sometimes there's a little bit of a delay before I get around to doing it, but it will be done. So just bear with me. Also, I haven't removed, I've been uploading my videos on YouTube for a number of years now, and I haven't deleted any videos. So if you scroll all the way down on my channel, go back to last year this time. Last year's videos will also be there if you want to watch them. Okay, so for today, we need to do units 4 and 5. Just to recap, to summarize what we've done so far, is last week we looked at the concept of a company, uh, focused specifically to start off with on the fact that a company is a juristic person. The individuals comprising the shareholders of the company are not personally liable for the debts of the company. Neither do they own the assets. The company is a separate entity, separate from its members. We also looked at what makes a company unique as a juristic person is the separation between ownership and control. You have ownership, the shareholders or the members, and then you have the board of directors on the other hand, that manage the company. I pointed out to you at the time that it's not strictly speaking correct to say they manage the company. They are in charge of oversight. They oversee the management. They don't necessarily do it themselves. Then we learned about different types of companies. Two main types of companies: companies with a shareholding, companies without a shareholding, also known as companies limited by guarantee. Companies with a shareholding divided into public companies and private companies. Taught you how to distinguish between the two. I taught you uh, about the provisions that must be contained in the constitution of a private company to make it a private company. And I pointed out that the Companies Act is written for public companies and then it makes exceptions for private companies. So when you answer a case study, always be aware of what type of company I'm referring to in the case study, because the answers could differ. Your answer could differ regarding to whether this is a public company or a private company. Companies without a shareholding, companies limited by guarantee, not conventionally used for business purposes, but your non-profit companies, your Section 21 companies, are companies limited by guarantee. They are public companies, so all the provisions in the Act regarding public companies also apply to them. Now, as I was going on last week, yes, Mr. Kluter?
Good afternoon, ma'am.
Yes, Mr. Kluter.
Are you representing something? Because there's nothing showing on my screen.
I haven't uploaded the
Oh, okay.
PowerPoint yet. I'm
Okay,
just
then we're on the same page.
absolutely on the same page. Wonderful. Okay, I'm going to upload the PowerPoint shortly. We'll share my screen shortly. At the moment, I'm just still talking to you, recapping what we did last week so that to refresh your memory. And then you will remember that last week I explained to you I was using words that were obviously strange to you. I was talking about the constitution of a company. I was talking about the articles of association, the memorandum of association, things that you don't know about or that we haven't studied yet. Working in the accounting business, you might have come across it in the course of your work, but we have. So then I explained it's a bit difficult right in the beginning to know where to start, because in order to understand certain things, you have require prior knowledge of other things, and to understand those things, you need prior knowledge of that, and to and fro. But I told you to just please relax. It will all fall in place. So that is where we are getting this in tonight's class. So, Mr. Kluter, I'm about to share my screen now. Okay, just give me a hands up quickly. If you can see the screen, if I've successfully shared that. Berta, your hand is up. Is that a yes or is that a question? Oh, we are. Okay, you've raised you lowered your hands. Okay, so fine. So unit 4 then. We did units 1, 2, and 3 last week. Unit 4 is about the formation of a company, the birth of a company, so to speak. How does a company start? Formation of a company, your learning objectives. I'm not going to read through them. As I've said previously, always once you've worked through a particular unit, go back to your learning objectives and check that you can actually answer these questions. Also very important, on e-learning, I have shared some worksheets with proposed suggested answers. I suggest you download and work through these worksheets. The tests are often, and exams are often, feature the question or some of the questions that are in the worksheets. So in preparation for tests, go through those worksheets and look at the suggested answers. They're not always model answers. Sometimes it's just pointers saying you should discuss this, that, and the other. But previous years students have found that very useful. So a company becomes a company when it is registered. The shareholders that want to start the company, they're also known as the promoters. They take the necessary steps. There's a number of documents that have to be completed. These are quite bulky documents sometimes. It's a thick set of documents. which is then registered, lodged with the Registrar of Companies, BIPA, the Business and Intellectual Property Agency. When it is, and the people working for BIPA check the documents, and if everything is in order, everything is being submitted, the registrar places his official stamp on the document and gives it a number. That number, the registration number of the company, is like an identity number. It must be used on all official documents. Once it is registered, it comes into existence. It becomes a juristic person. Before registration is also known as incorporation. You can use the terms registration and incorporation interchangeably. They are synonyms. They denote the same thing. Before it has been registered, before it has been allocated this distinctive number, it does not exist. It is a nothingness. It is born, so to speak, upon registration. Now, these documents that are lodged with BIPA is known as the constitution of the company. Constitution of a company, in terms of the Namibian Companies Act, consists of two documents: the Memorandum of Association and the Articles of Association. Be careful here. If you look at South African textbooks, for example, South African legislation is different here. In South Africa, there's only one document. They don't have a separate memorandum and articles. They have a memorandum of association, a memorandum of incorporation. That's the correct term. So just don't get confused. Our company's law is similar to South Africa, but there are also aspects where it does differ quite a bit, which I have provided you with comprehensive study notes rather than prescribing a textbook. We don't have Namibian textbooks on company law, so I'd have to prescribe a South African book, which is just going to confuse you. So there are these two documents that each serve a particular role. The Memorandum of Association is the founding document. It contains a list of important information. It's normally only 1 or 2 pages long. It's not a very long document, but it contains certain very important information about the company, namely the purpose the name of the company, the shareholding, the purpose for which it was formed, etc., etc. The Articles of Association, on the other hand, contains the rules in terms of which the company is to be managed, sets out the rights, duties, and powers of members, rules regarding the manner in which the affairs are managed, rules to be followed during meetings, meeting procedures, etc., etc. Whereas the memorandum is a short document, the Articles of Association can be quite voluminous, can be a thick stack of documents. Now, it is important for you not to confuse these two documents. Don't tell me in the text that the name is stated in the articles, because that will be wrong. Don't tell me that voting rights is contained in the memorandum, because that will be wrong. If you are not sure about particular information, in which of these two documents you will find it, if in doubt, leave it out. If you're not sure memorandum or articles, just refer to the Constitution. Constitution is both these documents. So if you say so and so and so, this and this is in the Constitution, it will be correct. But if you say it's in the memorandum and it's actually in the articles, that will unfortunately cost you marks. If in doubt, leave it out. So companies have names. Every company has a unique name. The name of the company is stated in the Memorandum of Association. The first step that you do if you want to register a company is to apply for the name of the company. You apply to reserve a name. The registrar and the personnel will then check whether you are allowed to use this name. The registrar has the right to refuse reservation of a name if he or she believes that the name is undesirable. Name will be undesirable if it too closely resembles the name of a company that has already been registered and might cause confusion. It will also be considered undesirable if it contains language that proper, well-mannered people don't use in public. And then the name of the company is then followed by the particular statement indicating the distinctive last word, indicating the type of company. We looked at these last week. Public company ends with limited, private company, Pty limited, etc., etc. Now, an important aspect about the use of company names. I've started here. Important, this is for possible assessment. The full name and registration number of the company must be displayed outside the registered office or any other office where the business of the company is carried on. And it must be mentioned in all official publications and documentation of the company. So the official letterhead of the company must indicate the full, complete name, correctly spelled, the way it is registered, as well as the registration number. Now, a very important provision attached to the use of company names. Got it there, the third bullet point, it's printed in bold. The little star there saying go back to Unit 1. Unit 1, the juristic person. The concept that the company, that the members are not liable for the debts of the company. I pointed out to you that there are exceptions to this. Piercing the corporate veil, looking behind the registration to the individuals and potentially holding them personally liable. Now, this is the first of such instances that we come across. I told you last week that as we come across them, I will point them out to you. So this is the first instance where the director or officer of the company can incur personal liability. Companies Act states that any director, officer, or person acting on behalf of the company who signs or authorizes the signature of the exact wording of the section says any negotiable interest instrument or order for money. We don't use checks anymore, so negotiable instruments not so particularly relevant, but orders for money or goods. So if there's an official order and the company's ordering something, the director or officer who has signed this document on which the company's name is not correctly stated, full name and registration number, can be held personally liable on that document if the company fails to pay. So if Josephine is a director of ABC Pty Limited, whatever the registration is, ABC Pty Limited has ordered $500,000 worth of goods from us, and now the company isn't paying. Under normal circumstances, you're beginning to understand this. I said you cannot claim your money from Josephine. You can only claim it from ABC Pty Limited. But now you look closely at this order and you notice it refers to ABC Pty Limited, but the registration number isn't there, so the name wasn't properly stated. Under those circumstances, you can hold Josephine personally liable for the amount of that document. Not for all the debts of the company, but only for the amount of that document. So personal liability can arise by virtue of the incorrect use of the name of the company. So that is the details of the Memorandum of Association. The information which is contained there is the name of the company, the object of the company, the reason why the company was registered. In terms of the 2004 legislation, it is no longer a requirement to state the object of the company unless this is a Section 21 company. If it's a Section 21 company, you must state the object, which must be some charitable cause. But if you're registering a fishing company or whatever, it is no longer a requirement to state the object of the company. Then the memorandum contains details of the share capital, the number of shares that have been issued, or if it's a company limited by guarantee, this is where the clause will appear that the members undertake guarantee to contribute a fixed amount upon winding up. Any special conditions that will be applying to the company? We'll get to special. Oh, we have already come across an example of that. A special example of a special condition, the condition of in a Section 60B company, that directors and former directors will be held personally liable. That's where that is. If there are any pre-incorporation contracts, they will be mentioned here. We do pre-incorporation contracts, I think in Unit 8. And then the association clause. The association clause, that is where the people sign, the shareholders, members sign. Association clause must be signed by at least 7 people. If it's a public company, if it's a private company, only 1 member is required. Association clause contains full names and particulars of the signatories, how many shares they each agree to take up upon registration. I'm going to be looking at share capital in the next unit. But just quickly, while we have the slide where it says details of share capital, that refers to the authorized share capital, the maximum amount. That's usually 4,000 shares worth $1 each. The people who sign, the first shareholders, don't have to subscribe, take up all those shares immediately. 1 share per person is sufficient, but we look at that in the next unit. Important for you to remember here, we're going to get back to this again, is that the memorandum of association is only signed once. It is signed by the first shareholders of the company. They sell their shares and new members or shareholders join. They do not sign the memorandum again. It is only signed upon registration. Remember that that is relevant. Then the Articles of Association determines the way. Oh, if I just could quickly go back to that, that is the list of the items that are included in the Memorandum of Association. You need to have knowledge of them, but I will not ask you for 1, 2, 3, 4, 5, 6 marks to list them. You just need to know, where does the object go, where do special conditions go, etc., etc. But I won't ask you for a list. Then the Articles of Association determines the way in which the company is to function, the rules that have to be followed, how meetings will be conducted, how directors are appointed, that type of thing. Now, the most important part of Unit 4 is in this slide. That is paragraph 8 of Unit 4. The legal relationships arising from the Constitution. The constitution of a company is a contract. Did law of contracts last semester. You know what a contract is. It is a contract that has both horizontal operation between the members as against each other, and vertical operation between the company and its shareholders in their capacity as members. It is a contract. It is binding. The members have to do what is in that constitution. The company has to follow the rules in the constitution. If the constitution says for a particular decision you need shareholder approval, then the directors cannot legally proceed with that type of decision without shareholder approval. It is a contract. What is important, however, that you understand, I've just pointed out that it is signed only once. Section 71, you don't need to remember the section, but Section 71 of the Companies Act states, however, that the Memorandum of Association and Articles of Association are deemed to have been signed by each member to observe all the provisions thereof. So if you become a shareholder at a later stage, you don't go to BIPA and sign the document, but it is as if you have signed it physically. You are bound by it. You are deemed in law to know what it states, These documents filed at BIPA are public documents. Anybody, you can go to BIPA tomorrow and pay a small fee and get the registration documents of any company you wish to look at. You are deemed a shareholder, is deemed in law to be acquainted, to know and understand the contents, and to be bound thereby, even though they didn't physically sign. But now be careful, because I often ask questions about this relating to this part of the work. And then you answer and you say, but he's bound because he signed it. And immediately there's marks flying out of the window. He isn't bound because he signed it, because he didn't sign it. He is deemed to have signed it. Remember that. Also very important is that the Constitution is a contract between the company and its shareholders, members, in their capacity as members, not in any other capacity, not in their capacity as directors, for example. There's a very well-known court case. We look at it again when we do directors' duties, but just to illustrate what I mean by this, quite an old court case, but very well known. There was a gentleman who registered a company. He was the majority, or he held a certain number of shares. He wasn't quite a majority shareholder. He had something like 40% of the shares, and his sons had the rest of the shares. But in the Constitution, it stated that this father would be the managing director of the company for the rest of his natural life, so until he dies. Some years passed, and the sons became unhappy with the manner in which the father was managing the company and decided to remove him as director. They followed the correct procedures. We'll get to that when we look at directors. Followed the correct procedures and removed him, not as a shareholder, but as director. He was obviously very upset about this. How dare they remove him? He started the company. It's his company. He took them to court. And the judgment of the court was that, sorry, Daddy, the fact that the Constitution states you will be managing director for the rest of your life is not binding. They followed the correct procedure and you've been lawfully removed. Constitution does not form a contract between the company and its directors in their capacity as directors. Remember that. Any questions? That's Unit 4. Any questions about Unit 4?
Ma'am?
Yes, Albertina.
I just want to understand the last example you gave between the father and the son. Maybe I need to understand more on to know the binding contract.
Okay, let's go over it again. The Constitution, the Memorandum of Association of this particular company, had a provision which says that the father would, for the rest, as long as he's alive, be the managing director, the boss of the company. His sons got unhappy with the manner in which he was doing this job. So they followed the correct procedures. We get to that when we look at directors. We look at the procedures for removal of directors. I'm not going to go into that detail now, but they did everything correctly, followed the statutory provisions, to remove him as a director. They essentially fired him. So he was still a shareholder, but he was no longer a director. So he had no longer had any say in how the company would be run. But of course, he was unhappy about this. So he took his sons to court and say, but the Constitution says I must be managing director forever. The court said no. The fact that the Constitution says that, it shouldn't have been in the Constitution. From the Constitution, you get rights as shareholder, the right to vote at meetings, the right to dividends, but not the right to serve as a director. The Constitution is not a contract between the company and its directors to keep them as directors. Are you with me now?
Yes, does it mean now, according to the constitution of the company, the contract should be between the company and its shareholders?
The Constitution is a contract between the company and its shareholders. The shareholders derive their rights as shareholders from the Constitution. These rights are the right to vote, the right to, basically the right to vote and the right to dividends. Those are the two main rights that shareholders get. Those rights they get from the Constitution. But the Constitution does not give any person a right to manage the company, the right to be a director for life. Directors, there's a procedure for appointing directors. We'll look at that later on in the course, how are directors appointed. So I'm not saying they don't have any rights, but they get their rights from their contract of employment if they are employees, not from the Constitution. From the Constitution, you only get rights as a shareholder, the right to vote, the right to share in dividends.
Okay.
Are you with me?
Yes, ma'am.
Okay.
And the second one, I just want to understand. No, I was through talking when we're giving examples. I hear you saying, for example, if I give a question like this and you answer this way, that's a mark out. Does it mean now with the company law, the wrong answer is a mark deducted from you, or what is that mean?
No, don't worry. Don't worry, Albertina. I don't.
Okay.
I don't apply negative marking. I don't deduct marks. Don't worry about that.
All right.
But
okay,
if you say Albertina is deemed to have signed the Constitution and is bound to the contract, I will give you the mark. If you say Albertina signed the Constitution, I'm not going to subtract a mark, but I won't give you the mark either. Are you with me?
I see.
Yeah. So don't panic.
Yes.
I'm not going to start subtracting marks from you, because then there might not be anything left at the end of the day.
I just wanted to understand.
No, 100%. Thank you for asking. Okay,
right.
so
Thank you, ma'am.
Yeah. Thank you, Albertina, and keep up the questions, keep up the participation. I enjoy interacting with my students, even if it is online. Okay, so the next unit then, the capital of the company. We've already learned that companies with a shareholding get their capital by issuing shares. Now, you all come from an accounting background, and you'll realize that that isn't 100% accurate to say that. I mentioned informally that companies are normally registered with a share capital of 4,000 par value shares with a par value of $1 each. So that's $4,000. Now, you're not going to be getting a business going with $4,000. That, realistically speaking, you'll understand. So as accountants, you'll know there's a difference between share capital and loan capital. Operations are very often financed through loan capital rather than share capital. But companies, also companies with a share capital, derive their capital from the issue of shares. Let's share again. Okay, just give me a thumbs up if I've successfully shared my screen, if you can see the PowerPoint. Thank you, Susanna. Okay, the capital of a company. And I want to assure you that the further we go along with company law, the more you learn, the more sense everything will make. The pieces will start falling together. So if at the moment you're a little bit confused, don't get too panicked. Albertina asked me about directors. It was a bit difficult to completely answer her question because we haven't done the appointment of directors yet. Once we've done a substantial amount of the units, all these questions that you might have at the moment in your heads will start sorting themselves out. So our learning objectives, remember to look at them. So Unit 5 starts off with certain basic concepts, just terminology. In my hard copy of the notes that I have next to me, I've actually drawn some lines through that. I won't assess you on these this different terminology. It's just an explanation of what is share capital, what are shares, what are securities, what is stock, etc., etc. You can just go through that yourself, just for your own education, so that you know these terms. Once again, as accountants, you are probably acquainted with this terminology in any event, but I won't assess you directly on these basic concepts. So I'm going to skip over these slides and then start here with paragraph 2 of Unit 5. You get two types of shares. Only two types of shares. And you've got to firstly, you get types, just for terminology's sake, you get types of shares, and then you get classes of shares. We're going to look at what classes of shares are in a while. Don't confuse these two. If I'm asking you, what are the two types of shares? These are par value shares, which have a fixed nominal value, and no par value shares, abbreviated as NPV shares, which are just fixed in number. There's no value attached to them. In South Africa, South African legislation has done away with the classification between par value and no par value. South Africa shares, all shares are no par value, because the par value is actually meaningless. I've already said companies are usually registered with shares with 4,000 par value shares with a par value of $1 each. Now, $1 in today's time is nothing. It can be a par value share. The par value share can have a par value of $1. but have a market value, a true value of hundreds of dollars, depending on how profitable the company, how valuable the company is. So the par value is not an indication of what the share is actually worth. It is merely an indication of the minimum amount that has to be received by the company upon issue. So if it's 4,000 shares, par value shares with a par value of $1 each, and you subscribe to 20 shares, the company has to receive at least $20. No true reflection, no reflection of its actual value. Companies, there's no rules as to which type of shares companies may issue. They can choose either par value shares or no par value shares. But all shares of a particular class, so all ordinary shares, must be either the one or the other. If it issues preference shares, all preference shares must be either the one or the other. But there's no rule as to which type of shares. Then the rest of the slide, I don't actually need to teach you. You are accountants. Authorized share capital. I mentioned that when we were doing the memorandum. The authorized share capital is stated in the memorandum of the company. 4,000 par value shares with a par value of $1 each. Also known as the registered share capital or the nominal share capital. It is merely an indication of the maximum capital that the company, the maximum number of shares that the company intends to raise through those shares. It can be varied, can be increased or reduced by amending the memorandum of association. The actual issued share capital does not appear in the Constitution, it appears in the balance sheet. Balance sheet indicates the total issued share capital, the number of shares of those shares that have actually been issued. Important provision there, a company cannot give away shares for free. Can only issue shares if the full issue price has actually been paid. So those are types of shares. There are only two types of shares. Par value, no par value. But there can be a number of classes of shares. We distinguish between three main classes: preference shares, ordinary shares, and deferred shares. But you can also, this is a decision to be made by the company. You can have different preference shares. You can have Class A preference shares, Class B preference shares, Class A ordinary shares, Class B ordinary shares, Class C ordinary shares, whatever. So how do we distinguish between, or what differentiates between classes of shares? When Albertina was asking me about the contract formed by the Constitution and the company's shareholders, I told her that the shareholders derive their rights from the Constitution. These rights are mainly voting rights, the right to dividend, and I skipped the third one, participation in distribution upon liquidation. That's if company closes down, winds up, all the debts are paid. If there's any capital left, that is then divided amongst the shareholders. But not all shareholders are the same. You could have different groups of shareholders who have different rights. Some votes might count more than others. Some might get a larger percentage of the dividends. Some might not participate in the distribution at all. What distinguishes between different classes of shares are known as class rights. Every class of rights is like, I like to compare it to a bunch of flowers. You get lots of bunches of flowers, but they consist of different flowers. They're still bunches of flowers, but they're different. Classes of shares, they're still shares, but the owners of those shares, the shareholders, have differing rights depending on the class rights of that particular class of shares. Where will we find the class rights? Either in the constitution of the company or in the conditions of issue. You can look up what are the rights of a particular class of rights. If the company chooses to issue only one class of shares, these will be ordinary shares and all rights will be the same. That is a company decision to decide, okay, we're fine, we're only going to have ordinary shareholders, everybody has the same rights, or we want to make some distinction between our different shareholders. Three main classes: preference, ordinary, and deferred. Let's look at preference shares. Firstly, a company can only issue preference shares if it has also issued ordinary shares. A company's share capital, authorized share capital, cannot consist of only preference shares. It can have only ordinary shares. Doesn't have to have preference shares. That is a choice. But it cannot have only preference shares. The reason for this is obvious if we start looking at the unique characteristics of preference shares. Preference shares stand first in the queue when it comes to payment of dividends. If the company declares dividends, that is a decision made annually by the directors. But if it declares dividends, the preference shares stand first in the queue to receive a little bit of money. And if there isn't enough money, it could well happen that the ordinary shareholders get nothing. So that is what makes them preference shares. They have a preferential right to dividends, which might sound wonderful, and in certain instances it is a good thing. But there's also always a flip side to a coin. Preference shareholders generally do not have voting rights. So you get a preferential right to dividends, but in exchange, therefore, you cannot generally meet a vote at shareholders' meeting. Unless, and there's two exceptions, and you've got to remember these exceptions. When we get to Unit 8, we're going to get back to these exceptions. No general voting right unless the dividend is unpaid, in arrears. The dividend or redemption payment remains in arrears and unpaid. I'm going to clarify that in the next slide. Or in instances where the resolution that they are voting about, the decision to be made, directly affects their class rights. That is known as variation of class rights. If there's going to be a variation, a change in class rights, then obviously the shareholders that own these shares have to vote, have a say in, do we agree with this change or not? So the ordinary shareholders cannot propose a resolution, make a decision that preference shareholders are going to be getting less dividends in future without the consent agreement also of the preference shareholders. So no general voting rights, except if their dividends is in arrears or if the decision affects their class rights. Now there's a special class of preference shares that are known as cumulative preference shares. Most preference shares are cumulative. In fact, the Act states that if the constitution or the conditions of issue is silent, so it doesn't state that these are cumulative or they are not cumulative, then they will be deemed to be cumulative. What does this mean? Cumulative preference shares are entitled to a dividend in respect of each financial year. However, declaring dividends remains a decision to be made by the directors, not by the shareholders. So, although your cumulative preference shares are entitled to a dividend in respect of each financial year, that doesn't mean they're going to get the cash every year, because the directors might decide, well, the company hasn't done well enough, or we'd rather retain the money for expansion or whatever reason. That is a decision to be made solely by the directors. However, if in a particular year no dividend is declared and they don't receive a payment, these outstanding amounts accumulate. Hence the term cumulative preference shares. They don't fall away. Ordinary shareholders, if no dividend was declared and they didn't get anything that year, then tough luck, maybe next year or the next. Cumulative preference shares, if you didn't get the cash this year, it doesn't fall away, it accumulates. And in a particular year, if dividends is then declared, that money that is available is paid in arrears. If the company pays dividends, dividends in respect of preference shares must first be paid in respect of each financial year that these were not paid. So if they didn't get anything in 2024 and they didn't get anything in 2025, 2026 there's some money available. Whatever is still owed to them back from 2024 will be paid first. And then if there's more money left, 2025 and then 2026, unless everything until everything has been paid. Although it states there in the first bullet point that cumulative preference shares are entitled to a dividend in respect of each financial year, as I've already explained, it does not give the shareholders an enforceable claim. Unpaid dividends do not give shareholders the right to claim. Dividends must first be declared. and that is a decision to be made by the board of directors. And then just the last bullet point there's a presumption in favor of cumulativeness. I've stated that if the conditions of issue are silent, it will be deemed that preference shares are cumulative. The company doesn't want the dividends to accumulate. It must be expressly stated when these shares are issued that these are not cumulative. So this, what I've explained here now, goes back to this bullet point here, where they generally have no voting rights, except if their preference dividend or a redemption payment remains in arrears and unpaid. So if the company didn't declare a dividend in 2024 and 2025, the moment it wasn't declared and it starts to accumulate, it is in arrears, it is unpaid, until such a time as it has been fully settled, they have the right to vote at meetings. Okay, before I get to that slide, I just want to go back to my window where I can see all your faces. Just want to check in quickly. Is everybody still with me? Is everybody following? Just give me a thumbs up if you're still with me. Thank you, Susanna. Just want to check in occasionally to make sure you haven't just logged into the class and then gone off to have a cup of coffee somewhere, that you're actually listening to me. Okay. So another class of preference shares that companies can issue, they don't have to issue it, but they can if they want to, is referred to as redeemable preference shares. Now, these redeemable preference shares can be cumulative or not, deemed to be cumulative, but what makes them special is that they are issued by the company under the condition that at a certain time and in a certain manner, as prescribed in the articles, the company will buy them back. Normally, at a premium, at a higher price than the shareholder paid for them. So redeemable preference shares, an investment vehicle used by people that want to invest in a company, but aren't particularly bothered about voting at meetings and decisions. They just have some disposable income that they want to invest and they want to return on their investment. So they can buy redeemable preference shares, get a guaranteed dividend for a couple of years because it's cumulative, and then eventually after a certain period of time, the company buys them back, they get their money back, and they receive a little bit more than they paid for it. Just a note, because I've picked this up in previous years, the decision as to the class of shares is made by the company. A company does not have to issue redeemable preference shares. So if you want to invest, you can't go to the company and say, okay, I'll buy $10,000 worth of shares, but I want them to be redeemable preference shares, unless the articles authorize the issue of redeemable preference shares. It's not up to the individual to decide what class of shares. Only buy whatever is available, whatever has been authorized. Just make sure you don't get confused there. Now, redeemable preference shares are redeemed at a time and in a manner as prescribed by the constitution of the company. The money used to pay the shareholders in terms of the Companies Act may only come out of two sources, namely out of the proceeds of a fresh issue of shares. So the company sells new shares, and that money that it gets in, that other newcomers are paying for those shares, they use to pay the existing shareholders whose shares are being redeemed, or out of divisible profits, profits that would have been available for the payment of dividends. Instead of paying dividends, they use the money to redeem preference shares. Companies Act is very strict about this. Warning here, it's not going to make sense right now because we're not at Unit 13 yet. When I was talking about redeemable preference shares, first bullet point there, it says they can be redeemed, they can be bought back. But please, when you are referring to the redemption of preference shares, do not refer to the buying back. Use the term redemption, because there is another provision in the Companies Act that we study in Section 89, Unit 13, that provides for a company to buy back its own shares. And these are separate, different concepts with different rules. I quite often ask you, as a knowledge-based question in assessments, to distinguish between the redemption of preference shares and a buyback in terms of Section 89. Not going to answer that to you yet. Albertina, I know you'd love to ask me to clarify that, but don't. We'll wait till Unit 13, then we're going to get back to this, and then I'll compare the two procedures for you. But terminology, if you're referring to redemption of preference shares, use the word redemption, not buying back. Okay, I pointed out to you that class rights can be changed. There in that slide, I said that if the resolution is to affect the rights attached to the shares, it's considered a variation, a change of class rights. Now, you will need to know, you will need to know specifically for the purpose of Unit 8. You need to be able to distinguish based on the facts of a case study whether whatever the company is proposing to do and whatever they're asking the shareholders to vote on is a variation of class rights or not. Because only if it's a variation of class rights do the preference shareholders get to vote. If it doesn't affect their rights, then they don't get to vote. Class rights can be changed only if 3/4 of the shareholders of that particular class have consented in writing, or if they have adopted a special resolution authorizing this change. Once again, I'm using terminology here, special resolutions. You don't know what special resolutions are yet. Be patient, everything will start making sense. In essence, what you can understand now is you cannot change class rights without the permission of 3/4 of the shareholders that own that particular class. So when are class rights varied? Variation of class rights is only if after the change, the rights differ in substance. So voting rights, they had so many voting rights, and now they're going to have less. Or they had the right to get such a percentage of the share of the dividends, and now they only have the right to get less. The substance of their rights has changed. There is no variation in class rights if the substance of the rights remains the same, but it affects the commercial value of the shares. The commercial value, the resale value of your shares is not a right. It's not something you can insist on. That's affected by the profitability of the company and the demand, etc., etc. It's not a right. So in order to determine in a particular case study whether this decision that is being voted upon affects the class rights, you need to judge for yourself. Make the decision for yourself, because I'm not going to tell you. You have to decide. Does this decision substantially affect the rights, or is it just affecting the commercial value? Question that you can ask yourself in order to answer this decision, does it affect the whole company? So they're selling the building that the company owns. So it affects the whole company, all the shareholders. Or does it affect only one particular class of rights, a class of shares who will now have less voting rights, etc., etc.? When we get to Unit 8, we're going to getting back to this as well, and I'll give you some examples of that. So let's just go back, because I don't have slides, a slide for this, but I want to quickly go back to this one. We've now spoken at length about preference shares. Ordinary shares, they stand next in the line. They are just ordinary. You can get different classes of ordinary shares as well, but no special rights attached to them. Deferred shares. Deferred shares are also sometimes known as founder shares. They have general voting rights, but they stand third in the queue when it comes to payment of dividends. Founder shares, your promoters, your people that start the company are often prepared to say, okay, I'd rather get in some other shareholders that can contribute capital, let them have ordinary shares. I'm happy. I'm not so much interested in getting a dividend, so I'm prepared to wait until all the other shareholders have gotten their dividends, but I want to vote. I want to have a say in the company. So deferred shares, third in the queue for the payment of dividends, but they have voting rights. Just to clarify that, because I don't have a specific slide on ordinary and deferred shares. Okay, so how do we acquire shares? How do you become a shareholder? You can become a shareholder in one of two ways. You can either acquire your shares directly from the company. You apply to the company. They agree to allocate a certain number of shares to you. That's referred to as allotment. Once you have paid the money, they issue these shares. These are new shares. They come into existence only upon issue. Before that, they don't exist. Or you can become a shareholder by acquiring existing shares from an existing shareholder. This has got nothing to do with the company. You pay, this is Albertina buying her shares from whoever. Usser. It's a contract between Albertina and Usser. She's prepared to pay whatever he wants for his shares. He pays her and the shares are then transferred to her. He is no longer a shareholder and she becomes a shareholder. Or maybe he's just sold some of his shares and he remains a shareholder. That is a contract, a deal between them. It doesn't affect the company. These are existing shares that have previously been issued. Are they transferred from the existing shareholder to the new shareholder by way of cession? Just give me a second. I'll be with you in a moment. Just think about that in the meantime. Okay, so that is acquisition of shares. Now, I don't know whether you have picked up since I started teaching you last week that sometimes I talk about members and sometimes I talk about shareholders. And sometimes I say shareholders, members, or whatever. But I've been using both those words. And you might have wondered, what is the difference? Why am I sometimes referring to shareholders and why am I sometimes referring to members? Now, in a certain sense, there is no difference. These words, terms shareholder and the term member, can be used interchangeably. I have been using them interchangeably. In a company that has issued shares, company with a shareholding, your shareholders are also members. You cannot be a shareholder without also being a member, and you cannot be a member without being a shareholder. Term shareholder is mainly or more often used when it comes to payment and receipt of dividends, whereas the term member is often used when it comes to voting rights. But it's the same person. If Bettina is a shareholder, she's also a member. When you are referring, however, to a company limited by guarantee, you can exclusively only use the term member because it hasn't issued shares, so it doesn't have shareholders. It only has members. Company with a shareholding, and most of our notes and teaching is based on companies with shareholdings, member and shareholder, yes, member and shareholder used synonymously, interchangeably. However, be careful. We've looked here at the acquisition of shares. How do you become a shareholder? How do you become a member? And read your test questions carefully. If I'm asking you, how does a person become a member of a company? Don't tell me by buying shares from an existing shareholder or by allotment and issue. Read your questions carefully. How do you become a member? In one of two ways. Either your initial members become a member by subscribing, signing the memorandum of association. Already pointed out to you that the memorandum of association is only signed once upon registration of the company. Anybody that becomes a member afterwards How do you become a member? By agreeing to become a member and having your name entered to the register of members. In a company with a shareholding, how do you agree to become a member? By buying shares. Once the shares have been transferred to you, that is seen as an agreement to become a member, and your name will be entered in the register of members. Explained this a little while, but earlier, in italics there, all shareholders are members, but not all members are shareholders. A company limited by guarantee only has members. Once again, be careful, read your questions carefully. If I'm asking you, whether I'm asking you how do you become a member of a company or how do you become a shareholder? Two different questions. Okay, and then the last thing that we look at, okay, there I have a slide with a light bulb slide for you. Do not confuse the acquisition of shares with obtaining membership. Just stress that. Then the last bit of this unit, companies do not only issue shares, they can also issue debentures. You might have heard that word before. What is the difference between shareholding and holding debentures? I've summarized it for you in a table there. A debenture is basically an IOU. Somebody, if you buy debentures, you're essentially lending money to the company. Your shareholders are the owners of the company. They have voting rights. Debenture holders are merely creditors. They do not have voting rights. You buy debentures as an way of investment, not because you want to have any impact on how the company is run. Shareholders can vote. They can influence the direction of the company. They only get dividends if they have been declared. They cannot insist on the declaration of dividends. Debenture holders get a fixed interest, which is paid at a fixed rate and a fixed time. Shareholders share in the surplus upon dissolution. Debenture holders are simply creditors. They will get them, if the company is dissolved because they're creditors, they will get their money back. But if there's anything left after all the debts have been paid, they don't share in the free residue. A question that I have asked previously, let me stop sharing. A question that I have asked previously, which I might ask again this year, is a little scenario where, a little case study where I tell you that Thandeka has inherited an unexpected amount of money from her great aunt that passed away, and she wants to invest in company ABC Pty Limited. To advise Thandeka, and company ABC Limited is issuing shares and it is issuing debentures. Question is, advise Thandeka how to invest in this company. Does she buy shares? Does she buy debentures? This is an open-ended question. It doesn't have a right answer or a wrong answer. In advising Thandeka, you have to explain to her What is a share? What is a debenture? What is the difference between the two? But whatever you finally tell her, Tandeka buy shares or Tandeka buy debentures, as long as you've motivated your answer, there's no right or wrong answer. It depends. What does she want? Does she want more involvement? Is she the type of person that likes being involved in decision making, that maybe feels that she can have some influence on decision making by voting at general meetings? Or does she literally just want to sit back and get her money? Also remember, because although dividends are not guaranteed, dividends are also not fixed. And the amount of dividends, if the company is very profitable, the amount of dividends paid to shareholders might exceed the fixed interest rate paid to debenture holders. It's more risky because you don't know if you can go to get it, but you could possibly get more. So, however, as long as you explain the difference, whatever you advise, your advice is, as long as you motivate it, is entirely up to you. You will get marks either way, which way. Okay, that's it for today. Any questions?
Ma'am,
Yes, Albertina.
as shareholders, can it also be called founding members?
Shareholders can also be called members. Only the very first shareholders will be the founding members. They will also be the founding shareholders. But if the company was registered already in 2024 and you become a shareholder now in 2026, you will be a shareholder and you will be a member, but obviously not a founding shareholder. The term founding means the very first. Anybody subsequent to that is not a founding shareholder, but yes, you can call them either shareholders or members. There, I don't distinguish.
Thank you.
Okay, any further questions? Asir, are you happy?
Yes, ma'am. So far, so good. Thank you very much.
Excellent. Mr. Bester, are you with us?
Yes, ma'am. Thank you.
Okay. You'll notice I choose only the easy names to pronounce when I'm calling out names. I don't want to mispronounce. I'm very particular about pronunciation of names. I don't want to take the chance of mispronouncing somebody's name. Let's try this one. Twa FIFA. Is my pronunciation correct there? Okay, Twa FIFA's mic is muted. I can't hear her, but I'm guessing she's not screaming at me because I'm pronouncing her name incorrectly. Okay, that's it for today. Thank you so much. I will upload the videos as soon as I have time. I will also, like I did previously, share the PowerPoint slides with you. They are on e-learning. Yes, Albertina.
Sorry, ma'am.
Yes.
I saw on the course outline. So the test one is an online thing, not face to face. Am I right?
I don't have the course outline open in front of me, but I think you're correct. I need to check. If you can give me 2 seconds.
Okay.
I just want to check quickly. There's an important issue that you've just raised by asking this question that I need to stress.
On this course line I have, it says venue to be confirmed, unless otherwise they changed.
No, I think that's the one which was
Is it
showing
the,
first, but the date of
oh,
2025. But I see the new one
yeah,
with
Yeah.
a 2026 date.
correct.
Yes. Saturday, 22 August, units 1 to 10 online. But now you need to be careful, be aware here, people. To share my screen quickly. Look at what I've highlighted there. Don't come back to me afterwards crying. Previously, the test, the online test and the face-to-face test were 50-50, equal weighting. I've changed that as from the semester. Totally within my right to do this. I double-checked the academic rules and regulations in the prospectus. It just says I need to give you 2 tests and a makeup test. Does not say they have to have equal weighting. Face-to-face test contributes 65% to your final semester mark, and the online test only 35%. Why did I do that? Because of the ridiculous results that I've been getting in the online tests, because people have been ChatGPTing their online tests. They cheat. Then they get 100% for the online test. Then they write the face-to-face test and they get 15%. Then they go into the exam with a inflated high semester mark. Not talking to any of one of you because you didn't write supplementaries. That's why you've already registered and started attending class. So I'll repeat this after next week when the students that wrote supplementaries for ITL have also joined us. I had students going into the ITL exam with ridiculously high semester marks, 70% semester mark, because they got 100% for the online test with an attitude of, I don't have to study. I've got a high semester mark. I don't have to study. And you know what happened? They didn't even get the 40% sub-minimum. Students with a 70-75% semester mark got 15-20% in a face-to-face exam. Had to end up having to write a supplementary. Once again, it's not you. Nobody that's in this class in front of me at the moment. Josephine, you passed first time around. So it's not everybody. Sebastian passed. Lots of people, not lots of people. Some people passed. The majority failed. Which is why I've made the decision to change the weighting. Online test will only contribute 35% to your final semester mark. Face-to-face test contributes 65%. You've got to study. You've got to write the the face-to-face test and do well in the face-to-face test because it prepares you for the exam. Because in the exam, you have to write sentences. You can't ask ChatGPT for the answer. So I'm going to warn you about that repeatedly, but I just, seeing that Albertina raised the issue of the date of the test, I thought I'll just use this occasion to just start alerting you about that. I'm going to have lots of students at the end of the semester that are going to be crying, but miss, that's so unfair. It's not unfair. At the end of the day, you have to be able to write a face-to-face test to pass the exam. So I'm really helping you in advance. Okay, thank you very, very much. Have a wonderful evening. I will see you next week. Bye.
Bye, ma'am.